This video is about certiorari, prohibition, and mandamus of your Rule 65, and this is our part 2. So we'll go now to prohibition. For the discussion about when petition for certiorari is proper, makikita nyo yan sa part 1 ng Rule 65. So just like your petition for certiorari, your petition for prohibition must be verified. That is very clear according to your section 2 of Rule 65. A person aggrieved thereby may file a verified petition in the proper court. And together with your verified petition is a certified true copy of the judgment, order, or resolution subject thereof, and there must be copies of all pleadings and documents relevant and pertinent thereto, and last is there must be a certification against forum shopping. So that is very clear according to the second paragraph of your section 2 of Rule 65. Also, do not forget your material date rule. Ano ulit yung material date rule? In actions filed under Rule 65, the petition shall further indicate the material dates showing number 1, when did you receive the notice of the judgment or final order or resolution subject thereof, and if you filed your motion for new trial or your motion for reconsideration, when was this filed, and lastly, in case your motion for new trial or motion for reconsideration is denied, when did you receive the decision? So take note of your material date rule. Mas madaling maintindihan ang concept ng prohibition if we are going to compare it to certiorari. Mas makikita nyo yung buong picture. But before we compare the two, let's go first to their similarities. What are their similarities? First is the ground. Ano ulit ang ground if you're going to file your petition for certiorari? That is an error of jurisdiction. The respondent acted without jurisdiction, or the respondent acted in excess of his jurisdiction, or with grave abuse of discretion that amounts to lack or excess of jurisdiction. So that is your ground if you're going to file your certiorari. That is also the same ground if you're going to file your petition for prohibition. Another similarity is what we call our common denominator. Ano ulit yung tinatawag nating common denominator? That there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law. So this is true when we talk about your certiorari, and this is also true when we talk about prohibition. So these are the similarities of certiorari and prohibition. So let's compare now certiorari from prohibition. Tapos na tayo sa similarities. Let's go now to their differences. We start with who is your respondent. Again, what did we say? In your petition for certiorari, it may be directed against any tribunal, board, or officer. In prohibition, nadagdagan yan, aside from tribunal, board, or officer, you now include corporation or person. Also, the respondent in certiorari must be exercising judicial or quasi-judicial functions. In prohibition, he may be exercising judicial, quasi-judicial, or ministerial functions. Pag pinag-uusapan si judicial functions, what does it mean? It means the power of the respondent to determine what the law is, what are the legal rights of the parties, and then he will adjudicate upon the parties their rights. So that is your judicial functions. How about your quasi-judicial functions? It applies to the actions and discretions of public admin officers or bodies. These public admin officers or bodies are required to investigate facts, they hold hearings, they draw conclusions, and they exercise discretion of a judicial nature. So that is your quasi-judicial functions. How about ministerial functions? Ministerial functions is where an officer or a tribunal performs in a prescribed manner. He does not exercise his or its own judgment. So that is a ministerial function. Another difference is their purpose or your prayer. What is your prayer if you're going to file your petition for certiorari? You want the proceedings of the tribunal, the board, or officer to be annulled or modified. Therefore, your certiorari, it is a corrective remedy. Again, it is a corrective remedy. You want that there be a re-examination by the higher court of the action of the lower court. That is what you really want if you're going to file your petition for certiorari. Therefore, your petition for certiorari is directed not to the court itself, but only to the cause or the proceeding in the lower court. Take note ha, it is directed not to the court itself, but only to the cause or proceeding in the lower court. How about in prohibition? What is your prayer or what is your purpose if you file your petition for prohibition? You want there the respondent, or you want to command the respondent to desist from further proceedings in the action or matter. That is what you want in your prohibition. Therefore, your prohibition is a preventive remedy. That is a preventive remedy. You want to restrain future action. Therefore, unlike your certiorari, your prohibition is directed to the court itself. That is directed to the court itself. So, ito na yung buong picture ng prohibition. So, ngayon nakikita nyo na kung ano ba talaga ang concept ng prohibition. So, in summary, your writ of prohibition is one which commands the person to whom it is directed not to do something. And the only effect of your writ of prohibition is it will suspend all action and it will prevent any further proceeding. If the thing is already done, it is clear that your writ of prohibition cannot undo it. Bakit? Your prohibition as a rule does not lie to restrain an act that is already fait accompli or that is your accomplished facts. Ano ba ang ibig sabihin niyan? Pag ginugal mo yan, ang ibig sabihin ng fait accompli is a thing that has already happened or been decided, leaving you with no option but to accept it. So kung yung building ay demolish na, then wala nang ipoprohibit ang court kasi na-demolish na nga. That is already an accomplished fact or your fait accompli. So let's go now to mandamus. Just like your petition for certiorari and petition for prohibition, your petition for mandamus must be a verified petition. That is very clear according to your section 3 of Rule 65. He may file a verified petition in the proper court, and together with your verified petition is your certification against forum shopping. That is also in the second paragraph of your section 3 of Rule 65. So let's recall the requisites of mandamus. Ano ulit ang requisites? Number 1 is that the plaintiff must have a clear legal right to the act demanded. In some jurisprudence, ang nakasulat is that the petitioner has a clear and unmistakable legal right to the act demanded. So pag pinag-uusapan ang clear and unmistakable, ano ang ibig sabihin niyan? Ano ang tinutukoy? It contemplates only those rights which are specific, certain, founded in law, clear, established, complete, undisputed or unquestioned, and without any semblance of doubt. Again, those are the rights that are well defined, clear, and certain. So therefore, in situations where the right claimed or the petitioner's entitlement to it is unclear, then the writ of mandamus will not lie. Your writ of mandamus is not the proper remedy if you want to establish a right or if you want to compel an official to give to the applicant anything to which he is not clearly entitled. Mandamus never issues in doubtful cases, or mandamus is not the remedy if you want to enforce a right which is in substantial dispute or to which substantial doubt exists. Another requisite of mandamus is that number 2, it is the duty of the defendant to perform the act because it is mandated by law. Number 3, the act to be performed is ministerial. Ulit, the act to be performed is ministerial and not discretionary. So when we talk about ministerial act, ano ang ibig sabihin yan? It is one wherein an officer or tribunal performs under a given state of facts. It must be performed in a prescribed manner and in obedience to the mandate of a legal authority. And when you exercise your ministerial act, there is no regard or exercise of your own judgment on the propriety or impropriety of the act done. The duty is considered ministerial when the discharge of the duty requires neither the exercise of official discretion or judgment. And again, in your ministerial act, nothing is left to the discretion of the person who must perform. Bakit? It is a simple, definite duty. It is a precise act, accurately marked out, enjoined upon particular officers for a particular purpose. How about your discretionary act? Kailan mo masasabi that the act is discretionary? Where the discretionary act is where the public officer has the right to decide how the duty shall be performed. When the duty shall be performed, then that duty or that act is considered discretionary and not ministerial. So ano pa ang ibang requisites ng mandamus? We go now to number 4. Let's read number 4. The defendant is unlawfully neglecting the performance of a ministerial act, or the defendant is unlawfully excluding another person from the use and enjoyment of a right or office to which such other person is entitled. And number 5 is what we call our common denominator, that there is no appeal, plain, speedy, and adequate remedy in the ordinary course of law. So these are the requisites of mandamus. Speaking of letter B, ground for your mandamus, ano ang sinabi natin? Let's compare that to your Rule 66. Your Rule 66 is your quo warranto. Kasi pag binasa mo siya, para silang parehas. Ano ang sabi dyan sa Section 1? You can file your action for quo warranto against any person who usurps, intrudes, or unlawfully holds or exercises a public office, position, or franchise. But what did the Supreme Court say? Well, quo warranto and mandamus are often concurrent remedies. However, there exists a clear distinction between the two. So for your mandamus, when can you avail or when can you file a petition for mandamus? What did we say? The plaintiff or the petitioner must have a clear, unmistakable legal right to the act demanded. So for your mandamus, what you want to enforce is clear legal duties. You do not want to try disputed titles. That is your mandamus. But in your quo warranto, what is your object? What is your purpose? What you really want there is you want to oust the holder from its enjoyment because you just want to try the right to an office or the right to a franchise. Another difference is if there is already usurpation or intrusion into an office, then quo warranto is the proper remedy. But in mandamus, the respondent here does not claim any right to an office. He just wants to exclude the petitioner therefrom. Therefore, the remedy is mandamus and not quo warranto. So, malinaw na. Pero para lalo ninyong maintindihan, si quo warranto, just remember this. If you're going to file your petition for quo warranto or your action for quo warranto, ask this question: by what authority or by what warrant? Because in quo warranto, what you really want is you want to ask the person to show you by what authority, by what warrant you are exercising, what authority do you have for exercising some right, some power, or franchise that you are claiming to hold. So that is your quo warranto. For application, let's read this 2001 bar exam question. Tingin agad sa tanong, is the court correct in its ruling and why? So let's go to the facts. There are two personalities involved here, and that is Fabian and Pablo. Fabian was appointed as election registrar in the municipality of Sevilla. He was supposed to replace respondent Pablo, who was transferred to another town without his consent. Therefore, Pablo refused to accept his transfer. He does not want to vacate his position. In fact, he continued to occupy and exercise his functions thereto. So, itong si Fabian filed a petition for mandamus against Pablo, but the trial court dismissed Fabian's petition, contending that the proper remedy is quo warranto and not mandamus. So, is the court correct in dismissing Fabian's petition for mandamus? This question is an actual case, taken from an actual case. But kung hindi mo nabasa ang case, you do not know the ruling of that case, what do? You go back to your basic concepts. Recall your basic concepts. And your basic concept is you compare your quo warranto from mandamus. Ano ba ang pagkakaiba ng dalawa? Again, what did we say? In your quo warranto, your object or your purpose really is you want to oust the holder from its enjoyment. What you want is you want to try the right to an office or franchise. But in mandamus, what you want there is you want to enforce clear legal duties. You do not want to try disputed titles. Again, what would we say? What are the requisites of mandamus? Number one, very clear, that the plaintiff must have a clear legal right to the act demanded. It means that the petitioner's right, in this case, Fabian, his right to the office must be specific, clear, undisputed, and questioned. There is no semblance or color of doubt, because mandamus never issues in doubtful cases. So that is your basic concept. So if you're going to apply that now to this problem, ano ang magiging sagot mo? Just like the answer of the UP Law Center, the proper remedy should be quo warranto and not mandamus, because the position here is a disputed position. Pablo continues to occupy the position. Pablo, your respondent Pablo, continues to exercise his functions, and according to him, he was transferred without his consent. Therefore, your right, petitioner, your right over the position is not clear, it is not founded clearly in law, it is doubtful. And in that case, since it is doubtful, mandamus is not the proper remedy. Another bar exam question, 2012, number 68 MCQ. You choose the most accurate phrase to complete the statement. Mandamus will lie. Choices are: mandamus will lie if you want to compel a judge to consolidate trial of two cases that is pending before different branches of the court. Or your mandamus is a proper remedy if you want to compel a judge to reduce his decision in writing, or if you want to direct a probate court to appoint a particular person as a regular administrator, or if you want to compel a judge to grant or deny your application for preliminary injunction. The answer here is letter B. Mandamus is the proper remedy if you want to compel a judge to reduce his decision in writing. Bakit? We'll discuss. As far as consolidation of cases is concerned, what is the applicable rule? That is your Rule 31, Section 1. If there is a common question of law, or if there is a common question of fact, ano ang sinasabi ng batas, there can be a consolidation of cases. But take note that ang sinasabi dyan, it may order all the actions consolidated. The word used is may. That is may. How about for the appointment as regular administrator? Under Rule 78, Section 1, when can you appoint, or who can you appoint as your executor or administrator, first is he must not be a minor or a non-resident of the Philippines, and the most important is, in the opinion of the court, unfit to execute the duties of the trust by reason of drunkenness, etc., etc. So that is according to the opinion of the court. How about for your preliminary injunction? Ano ang sinasabi dyan? What are the grounds for your preliminary injunction? A preliminary injunction may be granted when it established that you have these three grounds. Take note that according to the Supreme Court decisions, the judge in granting the preliminary injunction is given a latitude of discretion. Therefore, ano ang sinabi natin? If the law imposes a duty upon a public officer and that law gives the public officer the right to decide how the duty shall be performed or when the duty shall be performed, then that duty is discretionary. So for consolidation and for the appointment of an administrator and the denial or the granting of a preliminary injunction, the judge has the discretion to perform his duty. The law gives him the right to decide how the duty shall be performed, when the duty shall be performed. But how about the reducing of the decision of the judge in writing? Ano ang sinasabi ng batas? Very clear under your Rule 36, Section 1. In fact, what is the word used? The word used is shall. The judgment or the final order shall be in writing, personally and directly prepared by the judge, stating clearly and distinctly the facts, the law on which it is based, signed by him, and filed with the clerk of court. So ano ulit ang sinabi natin? If it is a ministerial act, it is done in a prescribed manner, it is a precise act, accurately marked out, it is a simple, definite duty, and the respondent is not exercising his own judgment. It is one which is nothing left to the discretion of the person who must perform. That is the reason why you're compelling a judge to reduce his decision in writing is a ministerial act. Mandamus is the proper remedy. 1991 bar exam question. After reviewing the record of a preliminary investigation of the homicide case, the Secretary of Justice reversed the resolution of the provincial prosecutor. So he directed the provincial prosecutor to move for the dismissal of the information which had been filed in the RTC of Pasig. So the provincial prosecutor thus filed such motion to dismiss. Question: may the RTC judge refuse to order the dismissal of the criminal case and insist on the arraignment and trial of the accused? Answer: yes, pwede. Bakit? Because once the case is filed in the court or once an information is filed in the court now acquires jurisdiction over the case. And what happens if the court now has jurisdiction over the case? Pwede niyang baliwalain ang decision ng Secretary of Justice because now it is now addressed to the discretion of the court. Another question: if the judge refused to grant the motion to dismiss of the provincial prosecutor, can you file an action for mandamus to compel him to grant the motion? Answer: no, hindi pwede. Bakit? Again, what did we say? Your mandamus applies only to ministerial duty. And what is involved here is a discretionary duty. Therefore, mandamus is not proper. In the case of Crespo versus Mugol, diniscuss dyan ng Supreme Court yung process ng pagpa-file ng criminal case. Ano ang sinabi ng Supreme Court? The institution of a criminal action depends upon the sound discretion of the fiscal. So, si fiscal ang merong teritoryo dyan if he is going to file the complaint or information, or if he is not going to file the complaint or information. In fact, kahit dun sa mga ebidensya, Si fiscal ang masusunod. The fiscal has that authority whether to submit or to present the evidence, or whether the evidence is sufficient not to establish the guilt or sufficient to establish the guilt of the accused beyond reasonable doubt. The reason why the placing of the criminal prosecution is under the control and direction of the fiscal is you want to prevent malicious or unfounded prosecution by private persons. It is through the conduct of the preliminary investigation that the fiscal determines the existence of a prima facie case that would warrant the prosecution of a case. So, meron kang preliminary investigation or your PI. But remember that the action of the fiscal or prosecutor is not without any limitation or control. Bakit? Because even if the fiscal decides that an information should be filed in court, ano ang mangyayari next? That is subject to the approval of the city fiscal or provincial fiscal or your chief state prosecutor. Tsaka lang maifa-file yan sa court. But that is also again subject for review to the Secretary of Justice, who has the power to affirm, modify, or reverse the action or opinion of the fiscal. The Secretary of Justice can direct that a motion to dismiss be filed in court, or that an information be filed in court. But once a complaint or information in court is filed, ano ang mangyayari? The court acquires jurisdiction over the case. The court acquires jurisdiction over the case once an information or complaint is filed in court. That means that the court now has the authority to hear and determine the case. And after filing of the complaint or information, the court will now make a judicial determination of probable cause, that is for the purpose of the issuance of the warrant of arrest. And in that case, if the accused voluntarily submitted himself or he was duly arrested, the court now acquires jurisdiction over the person of the accused. So again, what is the rule? Once a complaint or information is filed in court, any disposition, whether that disposition is dismissal, conviction, or acquittal of the accused, that now rests in the sound discretion of the court. That is now in the sound discretion of the court. Again, the fiscal cannot impose his opinion on the trial court if the case or if an information is already filed in court. The court is now the best and sole judge on what to do with the case before it. The determination of the case is within its exclusive jurisdiction and competence. In fact, ang sabi pa nga ng Supreme Court, in order to avoid a situation whereby the opinion of the Secretary of Justice who reviewed the action of the fiscal may be disregarded by the trial court, dapat ang Secretary of Justice nag-refrain na lang from entertaining a petition for review or appeal from the action of the fiscal when the complaint or information has already been filed in court, because the matter is now left entirely for the determination of the court. So that is the process. Take note of that. Another bar exam question 2012. A here filed a complaint against B for recovery of title and possession of land. That land is situated in Makati, but the case was filed in the RTC of Pasig. Therefore, B filed a motion to dismiss for improper venue. The RTC Pasig judge denied the motion to dismiss, which obviously was incorrect, alleging that the RTC judge is unlawfully neglecting the performance of a Ministerial Act. Aid now filed a petition for mandamus against the judge. So is mandamus the proper remedy? Answer of the UP Law Center is mandamus will not lie. The proper remedy should have been a petition for prohibition. Bakit? Again, what did we say? Mandamus is the proper remedy if you want to compel a ministerial duty. So, ang pagdidismiss ba ng case based on improper venue, is that a ministerial duty or a discretionary duty? Syempre, that is a discretionary duty. And since it is a discretionary duty, then you cannot avail the remedy of mandamus. Bakit naman prohibition? Why is the petition for prohibition the proper remedy? Because again, if you look at your prohibition, that is a preventive remedy. What you really want is you want to restrain future action and you want to direct that to the court itself. In fact, ano ang sabi ng Supreme Court? The only effect of your writ of prohibition is it will suspend all action and it will prevent any further proceedings. So ito talaga ang gustong mangyari ni A. Gustong mangyari ni A is suspend lahat ng proceedings in the RTC of Pasig because wala silang jurisdiction. So let's answer this problem in light of the new rules or yung 2019 amendments. So under your 2019 amendments, ano ang sinasabi niyan? You are not allowed to file a motion to dismiss. Your motion to dismiss is already considered a prohibited motion under Rule 15, Section 12, unless your ground is that the court has no jurisdiction over the subject matter or there is a litis pendentia or res judicata or there is a statute of limitations, then you cannot file a motion to dismiss. So ano ngayon ang gagawin mo? Just file your answer, and in your answer, you will put there your negative defense or your affirmative defense. And for your affirmative defenses, you can now include the grounds which we cited in your motion to dismiss. That is very clear according to your Rule 6, Section 5. Also relate this to your Rule 8, Section 12. Ano ang sinasabi ng Rule 8, Section 12? Another affirmative defenses is are these grounds that number one is that the court has no jurisdiction over the person of the defendant, the venue is improperly laid, the plaintiff has no legal capacity to sue, the pleading states no cause of action, or that the condition precedent for the filing of the claim has not been complied with. And according to your Section 12, your failure to raise the affirmative defenses at the earliest opportunity, it shall constitute a waiver thereof. And for these affirmative defenses, the court has the duty to resolve them within 30 calendar days from the filing of the answer. The court now has the duty to resolve your affirmative defenses within 30 calendar days from the filing of the answer. But as far as for this defenses, ano ba yung defenses? Under Rule 6, ito yung fraud, statute of limitations, released payment, illegality, statute of fraud, stopel, former recovery, discharge in bankruptcy, or any other matter by way of confession and avoidance. Ano ang mangyayari? The court may conduct a summary hearing within 15 days from the filing of the answer. And from the termination of that summary hearing, the court now has the duty to resolve the case within 30 calendar days, or the court has the duty to resolve the affirmative defenses within 30 calendar days. So, ganyan na ngayon ang rule. But if your motion to dismiss, if your affirmative defenses is denied, what will happen? You cannot file a motion for reconsideration. You cannot file a petition for certiorari on that basis, or a petition for prohibition or mandamus. What will happen? The case will continue. There will be a judgment on the merits, and your affirmative defenses will be raised on appeal. So ganyan na ang rule under the 2019 amendment. So please take note. So to reiterate, mandamus is only applicable to ministerial duty. Mandamus applies only to ministerial duty. But can you use the remedy of mandamus to require the performance of a discretionary duty to act? Answer: yes. Mandamus can be used to the extent of requiring the performance of a discretionary duty to act, but not to require the performance of such duty in a particular manner. Ano ang sabi ng Supreme Court? if the official or if the officer is abusing the discretion in his attempt in his performance of discretionary act, so much so that it already amounts to his failure to do the act as the law requires, then mandamus is the proper remedy. Mandamus is the proper remedy. The general rule again is that the court will not attempt to interfere with the exercise of discretionary power. Exemption to this rule are found in cases of, number one is if there is a gross abuse of discretion. Remember, it's a gross abuse of discretion, or if the injustice is manifest, or there is a palpable excess of authority. So para lalo nyong maintindihan kung ano yung sinasabi natin, let's take a look at this 2007 bar exam question. L here was charged with illegal possession of shabu before the RTC. Although bail was allowed under his indictment, he could not afford to post bail, so he remained in detention at the city jail. But for various reasons, the arraignment of L was postponed 19 times over a period of 2 years, and twice during that period, his counsel filed a motion to dismiss, invoking the right of L to a speedy trial. Both motions to dismiss were denied by the RTC. So can L now file a petition for mandamus? Answer, yes. He can file a petition for mandamus. Bakit? Mandamus applies to Ministerial Act. Is that a Ministerial Act? What did we say again? Although mandamus applies only to a ministerial duty, but you can also use the remedy of mandamus to the extent of requiring the performance of a discretionary duty to act, but not the performance of such duty in a particular manner. Ano ang sinabi ng Supreme Court? The general rule is that the court will not attempt to interfere with the exercise of a discretionary power, but there are exceptions. And ano ulit ang exceptions? There is a gross abuse of discretion, such as what happened in this case, manifest injustice, again, what happened in this case, or palpable excess of authority. Biro mo naman, arraignment lang, madali lang naman gawin ang arraignment, pero inabot ng 2 years, 19 times na postponed. So that is a clear example of manifest injustice and gross abuse of discretion. So this is also the answer of the UP Law Center. So pabasa na lang. Let's compare now your mandamus from your continuing mandamus. So under the rules of procedure for environmental cases, Section 1, Rule 8, that is your petition for continuing mandamus. If you will read that closely, marami silang similarities ng Rule 65, Section 3. First is the ground. Ano ba ang ground for your continuing mandamus? The same. The respondent is unlawfully neglecting the performance of a ministerial act, or the respondent is unlawfully excluding another person from the use or enjoyment of such right. And our common denominator, ano ulit ang ating common denominator? There is no plain, speedy, and adequate remedy in the ordinary course of law. And who is your respondent in continuing mandamus? It is any agency or instrumentality of the government or officer. But what is your purpose, or what is your prayer in continuing mandamus? Aside from damages, what you want here is you want to command the respondent to do an act or to do a series of acts until the judgment is fully satisfied. Until the judgment is fully satisfied, and this is all in connection with the enforcement or violation of an environmental law, rule or regulation, or a right therein. So this is your continuing mandamus. And another important item to remember is that in your continuing mandamus, you are exempted from the payment of the docket fees. So we're done with definitions and distinctions, requisites, and when is the petition for certiorari, prohibition, and mandamus proper. We will go now to injunctive relief. So what is your general rule? What is the general rule? Even if you're going to file your petition for certiorari, what is the effect? It will not interrupt the course of the principal case. Ulit, the petition shall not interrupt the course of the principal case. In fact, what will happen, sabi ng Section 7, within 10 days from the filing of your petition for certiorari with a higher court or tribunal, the public respondent shall, take note of the word shall ang ginamit na term, the public respondent shall proceed with the principal case. And the failure of the public respondent to proceed with the principal case, that is a sufficient ground for an administrative charge. That is a sufficient ground for an administrative charge. But syempre, pag may general rule, palaging may exceptions. So what are your exceptions? Number 1 is if there is a TRO or a writ of preliminary injunction, then it will interrupt the course of the principal case. If there is a TRO or a writ of preliminary injunction, then it will interrupt the course of the principal case. Another exception is your doctrine of judicial courtesy. Ano ba itong doctrine of judicial courtesy? To understand the doctrine of judicial courtesy, let's go now to this case of Milagros Panuncilio versus CAP Philippines. So what happened here? Miss Milagros here was dismissed by CAP Philippines. It has something to do with money issues. So what did Miss Milagros do? She filed a case for illegal dismissal. But what was the ruling of the labor arbiter? Sabi ni labor arbiter, the dismissal was for a valid cause, but the penalty of dismissal is too harsh. So the labor arbiter ordered the reinstatement of Miss Milagros, but to a position that is 1 rank lower. On appeal, ano ang sinabi ni NLRC? Sabi ni NLRC, labor arbiter, you are wrong. It reversed the decision of the labor arbiter. The dismissal of Miss Milagros Panuncilio was illegal, therefore she should be reinstated to her former position. Siyempre, si CAP Philippines challenged the NLRC decision in the Court of Appeals, questioning the NLRC decision via Rule 65 or your petition for certiorari. So again, let's go back. What is the effect if there is an NLRC decision? That decision is final and executory. That is an executory decision. So pag wala kang na-issue na TRO, pag walang TRO, walang preliminary injunction, then that decision is executory. But what did the labor arbiter here do? The labor arbiter did not issue a writ of execution because according to him, there is a pending petition for review. But ano ang sinabi ng Supreme Court? If a labor arbiter does not issue a writ of execution of the NLRC order for the reinstatement of an employee, even if there is no restraining order, then he could probably be merely observing judicial courtesy. He could probably be merely observing judicial courtesy, which is advisable if there is a strong probability that the issues before the higher court, in this case in the Court of Appeals, would be rendered moot if there is a continuation of the proceedings in the lower court. In such a case, it is as if a TRO was issued. The Supreme Court therefore approved the action of the labor arbiter and ruled that it is as if a TRO was issued. In summary, your doctrine of judicial courtesy applies only to lower courts and it is based on the hierarchy of courts. And if the lower court strongly believes that there is this strong probability that the issues before the higher court would be rendered moot if there is a continuation of the proceedings in the lower court, then it justifies the suspension of the proceedings before the lower court even if there is no writ or order coming from the higher court. So that is your doctrine of judicial courtesy. 2013 number 11 bar question MCQ. What is the effect of the pendency of Rule 65 on the principal case before the lower court? Choices are letter A, it always interrupts the course of the principal case. Letter B, it interrupts the course of the principal case only if the higher court issues a TRO or a writ of preliminary injunction against the lower court. Letter C, the lower court judge is given the discretion to continue with the principal case. And letter D is the lower court judge will continue with the principal case if he believes that the special civil action was meant to delay proceedings. The answer here is letter B. It will interrupt the course of the principal case if there is a TRO or a writ of preliminary injunction issued by the higher court. Down to our last slide. This was asked in 2003 in an action for specific performance, and the MTC defendant Sarah filed a motion to dismiss the action based on lack of jurisdiction over the subject matter. So Sarah filed a petition for certiorari with the RTC. Vince, on the other hand, filed with the MTC a motion to declare Sarah in default. The motion was opposed by Sarah on the ground that her petition for certiorari was still pending. Resolved the motion to declare the defendant in default. So pag ganitong tanong, nakakalito because combination siya, meron siyang jurisdiction aspect, meron siyang when can you declare your defendant in default, and then there is your petition for certiorari that is pending. Pag binasa mo pa lalo yung facts, marirealize mo na bakit kay MTC final that is an action for specific performance, and your action for specific performance is one that is not capable of pecuniary estimation. Therefore, RTC has the jurisdiction. But if you will try to carefully analyze the problem, ano talaga ang gustong tumbukin ni examiner? Gustong tumbukin ni examiner is if alam mo ba ang Section 7 ng Rule 65? What is Section 7 again of Rule 65? Even if you file your petition for certiorari, what is the effect? It will not interrupt the course of the principal case. Again, the petition shall not interrupt the course of the principal case unless there is a TRO, unless there is a writ of preliminary injunction. So yan ang gustong tumbukin ni examiner. So your answer here is the court can still declare Sarah in default because she did not file her answer, because there was no writ of preliminary injunction, there was no TRO coming from the RTC prohibiting the MTC judge from proceeding in the case during the pendency of the petition. Dapat ang ginawa ni Sarah when she filed her petition for certiorari, dapat sinamahan niya or nag-request siya for the issuance of TRO or the issuance of preliminary injunction. So this is the end of our video. Thank you very much for watching and have a good day.